Okay, Mr. Mizer.
Good morning, Your Honor. Ben Mizer, and may it please the court. Walmart found itself in a classic declaratory judgment dilemma, facing an enforcement threat from the Justice Department while caught between conflicting interpretations between federal and state law from state and federal regulators regarding its legal obligations. So Walmart sought declaratory relief in order to alleviate that dilemma. That lawsuit should proceed for two reasons. First, sovereign immunity does not bar it because the federal government forfeits its immunity from suit when it takes a definitive legal position and demands that parties change their day-to-day conduct in order to conform to it. Second, that suit was ripe because it states an actual controversy between adverse parties on a purely legal question, on a set of purely legal questions.
But you still have to have what's called an agency action, as you well know. You claim that, for example, that threats made during settlement negotiations constitute an agency action. I have a lot of trouble with that.
Yes, Your Honor. Walmart has pleaded multiple forms of agency action in this case, one of which is sanctions under the definition of sanctions within the definition of agency action in the APA. And the reason that an enforcement threat is a sanction, Your Honor, is because the definition of sanction under the APA includes other compulsory or restrictive action. And to say to a party, you must do X or else face sanctions, is a restrictive or compulsory step. Even if the court does not buy, however, that...
But that's true of a statute.
Pardon me, Your Honor?
Wouldn't a statute basically tell you you must do X or else you may face a sanction?
Well, I think that the statute is a congressional enactment, whereas an enforcement threat is a step taken by an agency. And the whole point of the Declaratory Judgment Act is to allow a party...
Let's say an agency puts a statute on its website, as I think most agencies do. Now that's the words of the agency.
Well,
if you violate X, you might be sanctioned.
But the whole point...
Website sanctions?
Pardon me, Your Honor?
Are websites sanctions?
No, Your Honor. Websites are not sanctions. However, if an agency puts on the website for the agency a statement that represents the agency's definitive policy as to a particular policy question, and it then tells a party, we demand that you conform your day-to-day conduct to the policy that we have just announced, then that is an agency action that Congress has said a party may seek pre-enforcement review of. And that is all Walmart did in this case. It sought pre-enforcement review of policies that the agency had announced, the DEA and the Justice Department had announced regarding Walmart's legal obligations under the Controlled Substances Act. And when the Steva Geigy case from the DC Circuit is a perfect illustration. There, the agency had informed parties via letters that its policy with respect to certain pesticide requirements were X. The party said, we believe that X is not statutorily consistent, and the party was able to seek pre-enforcement review in order to challenge that agency policy. And the DC Circuit, and opinion by Judge Starr, said, when the agency makes its views clear, that is enough to constitute agency action that allows the party then to seek pre-enforcement review. And here, Walmart has pled a whole host of agency statements regarding its enforcement, regarding its policies under the Controlled Substances Act. None of those policies are embodied in a regulation. None of them are embodied in statutory text. They are all shadow policies that the Justice Department has adopted for enforcement reasons. Nonetheless, they are definitive policies that Walmart was entitled to seek pre-enforcement review of. The complaint is riddled with these various both enforcement threats and agency statements. For example, at paragraph 60 of the complaint, Walmart explains that, or alleges, that the Justice Department informed it that it was categorically impermissible to fill certain categories of prescriptions. Walmart alleged that that was the department's policy, and what is more, the department took that position in a criminal complaint against another pharmacy. So the court should take Walmart's allegations as a given under the 12b1 posture of the case, but it need not, because the department has announced that policy in enforcement actions, criminal enforcement actions against other parties. In addition, Walmart alleges at paragraph 136 that the Justice Department's policy is that there are certain red flags that are categorically unresolvable. The Justice Department, again, has taken that position in other enforcement actions against other pharmacies, so this court need not guess that that is the definitive position of the Justice Department. I could go on, but the point is that once a party stakes out a definitive position, tells a party, look, you have to change your day-to-day conduct or pay a sum to make our enforcement threat go away, then a party is entitled to seek a pre-enforcement review of those positions. The Supreme Court in Medellin made abundantly clear that when it comes to government enforcement actions, a party doesn't have to just sit and wait for the sword of Damocles to fall. Instead, it can challenge the enforcement threat and the underlying basis for that threat. The underlying basis for the threat is the language of the Supreme Court in Abbott Labs, it's the language of the court in Medellin, and that is what Walmart is challenging here, the agency policies that form the basis for the threat. The district court concluded that these agency positions were too tentative because they were stated in the context of settlement negotiations. But I think the settlement negotiation context is a distraction, because when the government says to a party, we are going to bring an enforcement action against you, then that is an enforcement threat, period. The fact that the government might also be willing to settle that enforcement threat for a sum of money cannot suffice to immunize that enforcement threat from pre-enforcement review. Because the Supreme Court, again, in Medellin and Susan B. Anthony has made clear that pre-enforcement review is available in the teeth of an enforcement threat. The district court also reasoned that there was no agency action sufficient to trigger the sovereign immunity waiver in the APA because Walmart's challenge constituted a programmatic challenge. That is a misreading, respectfully, of this court's and the Supreme Court's programmatic challenge jurisprudence. In none of the cases that the district court cited, and in none of the cases that the plaintiffs, that the defendants rather, have cited, was the party who was bringing a programmatic challenge a party who was regulated and who was facing an enforcement threat from the government. Where a regulated party is facing an enforcement threat and challenges the underlying basis for that threat, the challenge is necessarily not programmatic. What is more, those programmatic challenge cases were ones where plaintiffs were challenging or were seeking wholesale review of, for example, a land management program or some other environmental policy. And that is hardly the case when Walmart is saying specifically that the government is seeking to bring an enforcement challenge for massive sums of money on particular questions regarding the meaning and duties arising under this Controlled Substances Act. The government's position here would mean that if there is no agency action because the government has not promulgated a final rule, a notice and comment rule, then pre-enforcement review is never available when the government is threatening a party with enforcement of unfounded interpretations of statutes or regulations. That is to say, in the absence of notice and comment rulemaking, if the government is simply relying
What is the undue hardship being imposed upon Walmart by these threats?
Pardon me, Your Honor?
What is the undue burden that's being placed upon Walmart? You're being threatened, and threat implies that it has a meaning of consequences and fear of something. What are you afraid of? What's the burden of Walmart? One of the questions when you seek pre-enforcement review, traditionally going back to the base cases, has to do with the fitness of it, and also, and if I look at this thing, what you're concerned about here is rules that require you to spot red flags, et cetera, et cetera. The fear of opiates is an extraordinary phenomenon. We all know that. Among other ambiguities in this business is that you ask someone if an opioid is a narcotic, you'll get different answers. The doctors will tell you it's not an opiate. The federal government says it is, on highly technical distinctions about the way in which the drugs operate. So you start with these very latent uncertainties, and I can understand the difficulties that companies like Walmart face, Walmart in particular because of its size. And my question is, though, comes back to that you want these assurances, but for other things, you want to be assured that your pharmacists don't have to quote second guess a registered license decision that a prescription serves a legitimate purpose. I have trouble with that because the implication of that is that you want to be secured with a blind eye.
Your Honor, the dilemma that creates the hardship that was amply pled in Walmart's complaint is that Walmart's pharmacists find themselves caught between a rock and a hard place because on the one hand, the government is telling Walmart and its pharmacists that there are certain prescriptions that can never be filled, while state regulators, state boards of pharmacies, state medical boards are saying, no, you have to fill those prescriptions because otherwise you are engaged in the practice of medicine. To take one clear example from the complaint, at paragraphs 55 and 89, Walmart alleges that the president of the Texas Board of Medicine has said that cease and desist letters should issue against pharmacists who second-guess prescriptions that were written by licensed prescribers. On the other hand, at paragraph 60, Walmart alleges that the Justice Department—
You're saying you're being whipsawed between state and federal regulation.
That is exactly right, Your Honor. And in a circumstance where a party finds itself on the horns of a dilemma, declaratory judgment jurisprudence is abundantly clear that that's the classic scenario in which declaratory judgment relief is available. And so the complaint that Walmart brought was not a complaint that the Justice Department refuses to settle. The complaint was that there is an insoluble dilemma with the sword of Damocles hanging over Walmart and its pharmacists, whichever direction they go, whether they comply with the boards of pharmacy who can revoke the pharmacy licenses, or whether they comply with the Justice Department's demands, which can cause Walmart to lose its registrations. Either way, they are in trouble with one of their regulators. And that is exactly the scenario in which declaratory judgment relief is available. And what is more, and what makes this case worse, is that the Justice Department's position on behalf of the DEA was based on guidance documents, it was based on other enforcement actions, it was based on statements to Walmart, it was based on positions that are not actually found in the statute or regulations. In other words, it was based on shadow regulations. And so that was all the more reason that Walmart needed to seek declaratory relief in order to determine what exactly are we supposed to be doing here in order to comply with the law. And that is what brought it to court. Now, the Justice Department now says—
You could have just, in theory, waited to be sued and then assert all your defenses at that time.
That is certainly the Justice—
You're concerned that chills your operations.
First of all, it chills the Walmart's operations. That's correct, Your Honor. And what is more, that course of action, much as the Justice Department may prefer it, is not actually required by law. Rule 57 makes abundantly clear that declaratory relief is available even where other adequate mechanisms for review may exist. And even in those circumstances, a speedy hearing is warranted. In addition, the Supreme Court in Abbott Labs specifically said that it may pose undue hardship on a declaratory judgment plaintiff to force it to wait for the sword of Damocles to fall and defend itself in the enforcement action.
What effect, if any, on this litigation, this case, does the pendency of the Delaware proceedings have?
It has no effect, Your Honor. For one thing, as mentioned, Rule 57 does not require that the declaratory judgment suit go away just because there might be adequate relief in another suit. Abbott Labs makes clear that the declaratory judgment plaintiff doesn't have to wait. What is more, if the Justice Department is right and the declaratory judgment case has to go away because now there is an enforcement action, then the Declaratory Judgment Act becomes meaningless and essentially doesn't exist for parties who find themselves facing enforcement threats from the Justice Department. Because they might be able to file a declaratory judgment suit, although the Justice Department maintains that it's unripe until there's an enforcement action. But even if they do file, then once the enforcement action gets filed, then the declaratory judgment suit goes away. And that means there's no point in having filed it in the first place. And that is not what Congress said. Rule 57 and the Supreme Court in Abbott and other cases makes clear that the enforcement action is justiciable and that courts have an overwhelming obligation to decide cases presented to them that fall within their jurisdiction. What is more, a declaratory judgment action is entitled to a speedy hearing under Rule 57, and an enforcement suit may take some time. All of that while, Walmart and its pharmacists find themselves caught between the horns of the dilemma that we already discussed. In addition, the Justice Department has not actually cited a single case in which a declaratory judgment case was dismissed because of a follow-on enforcement action. Instead, every case that they cite, as far as I can tell from their briefs, did in fact say that it may not make sense for there to be two suits, but the first filed suit is the one that should get adjudicated first. Now, to be clear, Walmart did not allege that the enforcement action shouldn't be filed. Walmart didn't seek injunctive relief against any enforcement action. Walmart simply sought declaratory relief on the purely legal questions presented in the complaint. And the purely legal questions under the Controlled Substance, this is not unprecedented. Other declaratory judgment plaintiffs have sought relief on purely legal questions arising under the Controlled Substances Act related to the meaning of that statute. The Monson case from the Eighth Circuit and the New Hampshire Hemp Council case, I meant to just say the Eighth Circuit, I don't remember which circuit I just said. The New Hampshire Hemp case from the First Circuit is another instance in which two parties wanted to engage in certain conduct under the Controlled Substances Act. The Justice Department and DEA officials had announced certain enforcement policies, and both the Eighth and the First Circuits had no difficulty saying those plaintiffs did not need to wait for the sword of Damocles to fall on them. They were allowed to seek declaratory relief in advance based on the fact that they faced a credible threat of enforcement. The Susan B. Anthony case makes abundantly clear that where a party is facing a credible threat of enforcement, as Walmart clearly was here, it does not have to wait for the enforcement action to come. It instead can seek legal review in advance. And if a pre-enforcement challenge is not available in circumstances where shadow regulations are being threatened against a party, the party has no choice but to change the day-to-day conduct of thousands of pharmacists, both within Texas and across the country, or instead just wait for the enforcement threat to fall whenever it might fall, then the availability of pre-enforcement review is non-existent in the context of federal enforcement threats. The Justice Department also maintains that the fitness and hardship inquiry under Abbott Labs is not met here. But for one thing, the Supreme Court has made clear that the fitness and hardship inquiries are prudential considerations, and it has, in Lexmark and subsequent cases, cast doubt on whether such prudential considerations are even appropriate in the Article 3 inquiry, which is all we are confronting here. The Article 3 inquiry, for ripeness purposes, is simply whether there is an actual controversy between parties of adverse interests on legal questions. That is clearly met here. The fitness and hardship inquiries are inquiries that relate to the prudential question of whether the district court...
Well, the Article 3 inquiry, the internal requirement of ripeness is the key point. And so, in essence, Walmart says, regulate, if you will, but don't push us between the state regulations and the federal regulations. Give us some guidance. And if you won't regulate instead of just talk, then we ask the court to give us guidance because we manage one of the largest companies in the country. That's what the fight seems to me to be about.
Respectfully, Your Honor, that is not Walmart. That is not the dilemma in which Walmart found itself. Instead, the Justice Department stated, both in statements to Walmart and enforcement actions against other pharmacies, that, for example, if you do not document the resolution of red flags before you fill a prescription, then you are liable. That is not a... So
I understand you say that's more than that is an effort to basically of regulation without rulemaking. I understand that.
And the same is true of the other requests that Walmart stated. Whether or not certain Trinity combinations, for example, are categorically unfillable, is not a request to DEA to do more. It is instead an assertion that that legal position is unfounded and it puts Walmart and its pharmacists in an insoluble dilemma. In addition, the assertion that a pharmacy is a corporation that operates pharmacies is required to investigate shipments before they ship and not to ship them after resolving, if it's unable to resolve any red flags. That so-called no-ship duty is not a request to DEA to do more. It is instead an assertion that DEA's legal position is wrong and it is not founded in the text of either the statute or the regulations. And so none of Walmart's legal problems with the Justice Department were requests for the federal government to do more. Perhaps the shortcomings in DEA in doing its job with respect to prescription opiates may be a source of the problem and of the epidemic, but it is not a source of the dilemma in which Walmart found itself with respect to these pure legal questions. The district court also asserted, with respect to the agency action requirement under this court's sovereign immunity jurisprudence, that the legal positions that Walmart was challenging and that the Justice Department had taken were not sufficiently fixed. For one thing, that conclusion runs headlong into this court's clear statement in its case law that the agency action requirement is not a final agency action requirement. What is more, if by fixed the district court meant definitive or not tentative, then we agree. And the Justice Department's legal positions that Walmart challenged were not tentative. They were quite clear. The Justice Department said, here's our position, conform to it or else. So that was fixed, I believe, in the sense that the district court used it. And that meant that the suit was both sufficed to meet the agency action requirement and was sufficiently ripe for purposes of the Article 3 challenge. With respect to the agency action requirement, Walmart's position, of course, is that that requirement, while binding law for this panel, is not actually consistent with the plain text of the statute. And this court, as a result, this panel, as a result, should not exacerbate the circuit split between this court and other courts, and instead should treat the definition of agency action as broadly as it is written in the APA to find that Walmart has adequately pled both agency action with respect to rules and agency action with respect to sanctions, such that the sovereign immunity waiver was in fact triggered in this case. But if the court believes that the agency action requirement was not met, then Walmart preserves its challenge to that requirement for their own banc review.
And which specific Fifth Circuit authority are you referring to there?
There are a number of cases, Your Honor, the Alabama, Cushata, Doe, and Alexander versus.
I assume Alabama and Cushata was the one, all right?
Correct, Your Honor. And I think Alabama, Cushata, if I may just elaborate for a brief moment, Alabama, Cushata perfectly illustrates the circuit split because the Ninth Circuit, the Alabama, Cushata alleged agency action that was insufficient was an Indian tribe's claim of a breach of fiduciary trust. And the Ninth Circuit, in the Navajo Nation case that's cited in the briefs, found that a breach of trust claim was sufficient to trigger review and trigger the sovereign immunity waiver under the APA. And so that circuit split could not be cleaner.
All right. Thank you, Mr. Mizer. You saved time for rebuttal. Ms. Carroll?
Good morning, Your Honor. May it please the court, Sarah Carroll on behalf of the government. In this case, Walmart seeks a broad and abstract, 9-pronged declaratory judgment broadly addressing the obligations of pharmacies under the Controlled Substances Act.
Well, it's hardly abstract as Mr. Mizer describes these conflicting obligations between state and federal. It seems to me that they're diametrically conflicting, and he describes it as an insoluble dilemma. Of course, those are his words, but it seems to me that that's exactly what Walmart is looking at here.
The existence of potentially conflicting regulatory obligations on a regulatory entity, a regulated entity, is not itself enough to warrant a declaratory judgment. The entity needs to seek some kind of concrete relief. And if you look, I encourage the court, if it hasn't already, to look at the declaratory judgment that Walmart is requesting. It's reprinted on page 11 of our brief. And Walmart is asking for 9 declarations that address broad issues that can only properly be litigated in concrete factual situations.
So how are they going to do that?
Well, one way that they can do that is in the pending Delaware action that you noted, Your Honor. My friend was mistaken to suggest that courts considering declaratory judgment requests don't take into account the existence of an enforcement suit or a coercive suit in a private dispute. That is simply incorrect.
No, that's against a different entity, right?
No, Your Honor, it's against Walmart, and it presents the same issues as this case. The United States has sued Walmart in district court in Delaware on the same theories that Walmart is trying to litigate here. So what Walmart is trying to do is have the district court in this case issue this declaration setting out statements of law. You know, pharmacists never need to second guess prescriptions written by doctors and so forth. And as far as I can tell, Walmart anticipates that the Delaware district court will then take these declarations that the Texas district court made and parse them and try to apply them to the hundreds of paragraphs of actual factual allegations that the government has made in the Delaware suit. Walmart cites no case in which something like that has happened, and to the contrary, we have cases like Morgan Drexen in the DC Circuit, in which a party brought a declaratory judgment suit sort of on the eve of enforcement by the Consumer Financial Protection Bureau, seeking a declaration that the CFPB was unconstitutionally structured. The CFPB then filed an enforcement action, and the DC Circuit held that the declaratory judgment case should be dismissed because, you know, whatever Hobson's choice, whatever sort of Damocles the company might have alleged it was facing earlier, that had been resolved because the enforcement suit had been filed, it had a forum in which to make its claims, and that it would violate basic principles of comity and equity for one court to be issuing a declaratory judgment essentially about the case that another court was considering. And that's exactly what we have here. As the court is aware, the Delaware District Court is holding a hearing on Walmart's motion to dismiss. in 3 weeks. That motion raises the same issues that Walmart seeks to litigate here.
So what you're saying, if I understand, correct me if I'm wrong, is you're basically saying that Walmart is just engaging here in forum shopping.
I don't want to accuse Walmart of anything, and of course, one thing I want to make clear is that parties do sometimes seek pre-enforcement review.
So companies forum shop all the time, and there's nothing unlawful or unethical about that. I'm just trying to understand what it is that you're saying that Walmart is trying to do. To me, it sounds like you're suggesting that they're forum shopping.
Your Honor, I don't think it's forum shopping exactly, but I think that they are, by continuing to proceed with this case while the Delaware case is proceeding and has teed up all the same issues, they are trying to have one court weigh in on the same issues.
So what? I mean, that's just the practice. What about the merits of the claim?
So on the merits of the questions of whether the issues are ripe and things, of course we're not litigating right now the question whether Walmart's requested declarations are correct, but
Could I ask you just to speak a little more slowly?
I'm sorry, Your Honor.
Thank you.
Judge Higginbotham, you noted in your discussion with Walmart's counsel that the issues Walmart is trying to litigate here turn on very important and highly technical distinctions, and that's absolutely right. So just to take one example, Walmart requests a declaration that pharmacists are never required to second guess prescriptions written by doctors. That goes to a regulatory requirement contained in 21 CFR 1306.04 that says that a pharmacist can be liable for knowingly filling an invalid prescription. So the question essentially is whether a pharmacist can ever know that a prescription written by a doctor was invalid. And I can think of an infinite number of factual scenarios that could raise that question. I can think of cases in which a doctor could write a prescription and a pharmacist could see it and say, I know that is not a valid prescription. You know, if the prescription was for 1,000 pills or something, to take a really extreme example. And I can think of cases that would be closer. But the point is that this case in which Walmart is trying to seeking to litigate these things in the abstract, absent factual context, that is not the way to do it. And it's very similar actually to the Supreme Court's decision in Texas v. United States, in which the state had sought a declaration that the Voting Rights Act would never apply to a certain type of state action under a state statute. And Justice Scalia, writing for the court, said, no, we are not going to consider the question in this posture. We're not going to try to affirm a negative and say that there could never be a situation in which the Voting Rights Act would be implicated. And here Walmart is asking the court to affirm a whole host of negatives and say that a pharmacist could never violate applicable regulations by filling a prescription written by a doctor, that a pharmacist is never required to reject a category of prescriptions. Again, this is another one where I think the circumstances are really important. I can think of categories of prescriptions that a pharmacist would know are not valid, and there would be harder cases, but all of this is teed up in the Delaware suit and shouldn't be litigated here.
What's going on in Delaware exactly, from your viewpoint?
So what's going on in Delaware is that in December of last year, the United States filed a civil complaint against Walmart and alleged that Walmart had violated the Controlled Substances Act and regulations implementing it, basically by being too lax in dispensing opioids at its pharmacies, and also in conduct that took place up until 2018, also distributing opioids from—
Who are the parties to that litigation?
The United States and Walmart.
It's just
Same parties as here, and same issues. One thing I want to make clear is in its reply brief, Walmart says that there is one issue in its 9-pronged declaratory judgment that will not be addressed in the Delaware suit. This question of whether a pharmacist needs to write down his reasons for filling a prescription, and that is actually mistaken. Even as to that one example, that is raised in the Delaware suit. Starting at paragraph 79 of the government's complaint in the Delaware case, The government explains that the statute and the regulations require pharmacists to operate in the ordinary course of professional practice, and that part of professional practice is resolving red flags that prescriptions present and documenting their resolution. So there actually is complete.
What's the current status of that litigation? I think you stated earlier, I didn't follow it. Exactly what stage is it and what's going on there?
So Walmart filed a motion to dismiss the United States complaint over the summer, maybe it was in the spring, and the district court has scheduled a hearing on the motion to dismiss for November 22nd. So 20 days from now, the district court in Delaware will be considering.
Hearing on what, I'm sorry?
I'm sorry, Your Honor?
It scheduled a December hearing on what?
A hearing on Walmart's motion to dismiss the entire case.
The motion to dismiss.
Yes, and the motion to dismiss addresses all the same issues that Walmart is trying to address here.
What's the reference in the pleadings in that case to this one? What is Walmart telling the district court in Virginia about this litigation?
My recollection is that Walmart doesn't say much of anything. I know
Is
that
anybody, are these two courts going and just, we got litigation here, litigation there?
yes, I think it's unusual and strange, and if Walmart received the relief it's requesting here, which is this declaratory judgment, I assume Walmart would claim that that was then res judicata in the Delaware suit, and the Delaware judge.
I understand that. So in that sense, it's not really a pre-enforcement action at all. It's just a race to adjudicate.
Right. Walmart filed this suit several weeks before the enforcement suit was filed. But as Judge Smith noted, the impetus for the suit and what the suit is trying to challenge are apparently statements that unidentified people from the government made in the course of settlement negotiations that led up to the filing of the Delaware suit. And that is really extraordinary. I don't know what the limit to Walmart's position is. There doesn't seem to be a limit. By Walmart's lights, it seems that anytime a government employee says something about the law, someone can go to court and try to get a declaratory judgment about that. If I was in the court's mediation program.
Well, what relief does the government seek in that Delaware case?
Civil penalties and injunctive relief.
Against Walmart?
Against Walmart, yes.
And injunctive relief, could be a little more descriptive. What do you seek to compel them to do, to abide what does the government seek to have the district court order Walmart to do?
The government seeks to have the district court order Walmart to pay civil penalties and to comply with the Controlled Substances Act and its implementing regulations in its future conduct of its pharmacy business.
Okay.
Another point that I want to make, which we raised in our response brief and Walmart has no response to, is the Supreme Court's decision in Calderon, which held that to present a justiciable controversy, a party must seek to resolve an entire controversy. So in Calderon, an inmate filed for a declaratory judgment that California would not qualify for certain procedural advantages under EDPA, and the Supreme Court held that he could not pursue that claim, that freestanding claim, because the actual dispute would be whether this person was entitled to habeas relief. And in litigating his declaratory judgment case, he was trying to kind of peel off a legal issue that could be relevant to that future dispute, but wouldn't itself resolve an entire controversy. And the same is true here. Walmart is trying to get a declaration, for example, that the government can't enforce guidance and needs to enforce statutes and regulations, something that we agree with, actually. But even putting aside the merits of that, it is not itself an entire case or controversy that Article 3 would permit a court to adjudicate.
Why wouldn't that theory, if they were to win on that, lead to elimination of entire causes of action?
Because the cause of action here is not a cause of action to enforce guidance. The government is enforcing the Controlled Substances Act and regulations. This is not a case.
Right, but if there's a declaration that a particular guidance isn't actionable, then that disposes of any theory based on that guidance, wouldn't it?
I think Your Honor is correct that if there were some other case in which the government was saying, regulated party, you violated guidance number 365 or whatever, and we're gonna come after you. In that case, maybe, there could be questions about whether the guidance was reviewable, whether it had the force of law as necessary, but I want to be clear that we are not trying to foreclose that type of suit. We recognize that pre-enforcement review exists and can be available in appropriate circumstances, and we're not really even quarreling with any of the cases that Walmart cites. But what we're saying is that here, Walmart is coming to court not trying to challenge something in the way that litigants have in those other cases. Walmart is not saying this guidance is unlawful and it's going to be the basis of an enforcement action, so please invalidate it, or this statute is unlawful, this regulation is unlawful. Walmart is saying someone unidentified from the government took the position that, X is true, and district court accept our characterization of that position, and on the basis of it, issue this declaratory judgment that essentially provides like a code of conduct for pharmacists to follow. That just bears no resemblance to Abbott Labs or to the cases in the criminal context that Walmart cites. Even this New Hampshire hemp case, there a DEA official had testified before a state legislature and taken the position that certain cannabis plants qualified as marijuana under the CSA and were therefore illegal absent DEA registration. And the First Circuit said, okay, that's a discrete legal issue. There is a real threat of prosecution under this statute. This won't open the floodgates because most cases won't present this kind of a discrete legal issue. They'll instead raise things that require factual development. But even that is a far cry from this case where Walmart is just trying to litigate things in the abstract when there is a concrete enforcement action in Delaware raising the same issues in the context of concrete challenges. I want to be sure I address all of the court's concerns, but I also don't want to take up too much of the court's time. So I'm happy to stop unless there are other things that the court is wondering about.
All right, thank you, Ms. Carroll.
Thank you.
Mr. Mizer, you save time for rebuttal. So Ms. Carroll is correct, of course, that the department did cite the Calderon case, and in your reply brief, you did not mention that. So now is your opportunity to give us your response to that.
Sure. Thank you, Your Honor. With respect to Calderon in particular, I think that the problem in Calderon was that the habeas petitioner was not actually challenging anything related to his petition. Instead, there was a capital review mechanism available under which certain habeas petitions could get expedited review, and states had to qualify for that mechanism. And that habeas petitioner said, look, California should qualify for expedited review. And the court said, this is not even about your habeas petition, so this is not an appropriate vehicle, which closely resembles the Article III ripeness jurisprudence of the Supreme Court and this court, where all of the cases say, of course, a case is not ripe if you're not actually facing hardship and if you're not going to get the relief that you're seeking from this challenge. But that is absolutely not the case here. Walmart and its pharmacists are on the horns of a dilemma, and if Walmart obtains the declaratory relief that it is seeking.
One of the difficulties I have is that you pleading that, and I understand the threat of litigation and et cetera in the normal context of trying to get the government to move and to give you guidance. But the reality is that you no longer face a threat. You're in litigation. And you have the opportunity to make your case there. And That's, so contrary to what you argued earlier, I find it very difficult to understand what this so-called empty threat is. Because all that translates to is yeah, it's a threat. We've been sued by the government, so litigate it. I mean, that's
Your Honor, if that is the answer, if the answer is that a party may file a declaratory judgment claim, but then the declaratory judgment suit gets wiped out once the government files its enforcement action, then there's the availability of declaratory judgment becomes a hollow promise. What is more, Ms. Carroll cited—
so you want declaratory relief, and you're in court, but you wanted declaratory relief because the government was making threats, and you had no forum. You have a forum. You may not like it, but that's a...
And Walmart is vigorously litigating in that forum. But what Congress has said in Rule 57 is that Walmart is not required to litigate only in that forum, and instead it may continue to pursue the declaratory relief that it initially sought.
So it just boils down to the fact you want to litigate. You don't want to litigate in Virginia. You want to litigate in this circuit.
Walmart is vigorously litigating in Delaware and has moved to dismiss on a number of grounds in Delaware. But the case that Ms. Carroll cited for the proposition that the declaratory judgment suit should go away once the enforcement action is filed was the Morgan-Drexen case cited in the briefs. It's the D.C. Circuit CFPB case that she referenced. And what the D.C. Circuit said in that case was there are discretionary grounds on which to dismiss a declaratory judgment action. And given the existence of enforcement action, the courts should exercise their discretion not to review the original district declaratory judgment suit. But the problem for the government in this case is that they did not actually invoke that discretionary grounds jurisprudence in the district court. The government never told the district court judge to dismiss on discretionary grounds. In fact, it said that discretionary grounds in footnote 8 of its motion to dismiss are not applicable here because there's no jurisdiction. And so if this court believes that the district court should consider exercising its discretion not to entertain this declaratory judgment action, then what this court should do is remand for the district court to consider those discretionary factors. The Supreme Court talked about this dilemma, or this problem, in Metamune. And at the end of the opinion in Metamune, the Supreme Court noted that the defendants to the declaratory judgment suit had invoked discretionary factors. And the court said, look, discretionary factors are uniquely in the competence of the district court. So we are not going to consider them in the first instance. What we're going to do is remand this case to the district court to consider its discretion and decide in its discretion whether or not it should decline to issue declaratory relief. And so if this court believes that that's the way this case should proceed, then it should, under that guidance from the Supreme Court, remand to the district court for that analysis in the first instance, because the government didn't raise it in the district court, and it's too late for it to have raised for the first time in this forum. If I may make one last point in rebuttal, I see that my time is
Actually, your time has expired,
Okay.
Mr. Mizer. Your case
Thank you, Your Honor.
both of today's cases are under submission, and the court is in recess until 9 o'clock tomorrow.